Hi, this is attorney Joe McPeak with Virtuoso criminal and DUI lawyers. So let's talk about some important strategies for defense of a domestic violence case. Every case is different, of course, but in my experience, a lot of domestic violence cases boil down to is the alleged victim going to participate in the case? Are they going to want to help the prosecution against my client? Will they be willing to testify against my client? And if not, what else is left for the prosecution's case to prove against my client? Now, some of my clients come to me and they say, well, the other person's not pressing charges, so we're okay. Well, that's unfortunately not always true. See, the district attorney is the one who decides whether the charges are filed, not the alleged victim, okay? You have to understand that. When the government and the courts get involved, there's this idea that, hey, we think that a crime has been committed and we think we can prove it, and that's why this case is coming up, not because this other person has chosen to press charges or not. Now, that being said, whether or not the alleged victim actually wants to help the government and help the prosecution is something that a domestic violence case could rise and fall on. And a lot of it depends on, like I said, whether or not the prosecution has additional stuff aside from the alleged victim's statement that actually helped them prove the case. Are there photographs of any injuries? Are there potential third-party witnesses, perhaps neighbors or bystanders, who are going to come forward and say they saw my client do something? And if so, are those accounts any different from what the alleged victim may have said at some point? And another thing that comes up is, even if the alleged victim is not going to take the stand against my client, do we have a situation where their prior statements might actually be admissible against my client in court? And this issue comes up under a really important part of the Constitution called the right to confront and cross-examine your accusers, which is part of your Sixth Amendment right. But the point you have to know is this. Generally speaking, the courts might be very keen on admitting statements from somebody if they're made in an apparent spur-of-the-moment setting. Those types of statements, for example, maybe on 911 calls or maybe immediately on the scene following police response, obviously a good defense attorney should prepare to keep those statements out, and there's many arguments can be made. But if the alleged victim made those types of statements, there should be some concern that maybe the government might be able to use them against the defendant in that case. And again, good preparation should take that into account. And another thing you have to worry about is there going to be any allegation that the defendant actually did similar types of abuse in the past, even if those cases never made it to court? If there's some indication that the defendant has done similar types of behavior against the alleged victim, or maybe other similarly situated victims, California rules of evidence actually say a lot of that stuff might be admissible against the defendant. And that can create a problem, because even if the alleged victim doesn't want to participate, a lot of the defendant's dirty laundry may come into court. So again, a good defense attorney needs to be aware of these things and how to deal with them and how to roll with those punches when they come up, whether it's in the course of pre-trying a case or in front of a jury trial. And obviously a lot of other important defenses like victim or witness fabrication, or whether or not my client's acting in self-defense. All of these things come into play during the preparation of a domestic violence case as well. Feel free to give us a call anytime for a free consultation at 1-8336-NO-JAIL. And also feel free to check out our YouTube and Instagram sites.